This matter is State versus Richards. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I think counsel are familiar with the virtual platform, so I won't go into all of that. You actually are very experienced with this by now. So with that, appellant, please identify yourself for the record and let me know how much time you wish to reserve for rebuttal.
Thank you. Good morning, everyone. My name is Norm Pattis. I represent JERMAIN Richards. I would like to reserve 7 minutes for rebuttal, please.
Thank you, counsel. As Senior Associate Justice McDonald informed you, he will be keeping the time. He will hold up a little placard showing that when you have 5 minutes, 3 minutes, 1 minute, and time is up. Whenever you're ready. Sir. I'm sorry. One other thing. Judge Joan Alexander is joining us today. Thank you very much, Judge Alexander, for being on this panel.
Thank you, Chief Justice.
Thank you. The sole issue on this case is whether there was sufficient evidence to sustain the charge of murder against JERMAIN Richards. And I'll cut right to the chase and say the testimony of the medical examiner alone in this case is sufficient reason to overturn the verdict. And here's why. Dr. Gill testified. He was not the doctor who performed the autopsy. That was Dr. Carver, and Dr. Carver's report was admitted as a full exhibit. But here was Dr. Gill's testimony. The remains of the body that were available, that is a portion of a leg and an arm, showed signs of disarticulation. That is, they showed signs of having been severed from the rest of the body by a sharp object. But those were all post-mortem disarticulations. In other words, the limbs had been removed after the death, if there was a death, of the decedent. And Dr. Gill significantly testified that based on the evidence he saw, there was no way to tell how it, meaning the death, happened, where it happened, when it happened. How then could he reach the conclusion that the disarticulation was homicidal violence if there was no evidence of death, and if the wounds and the evidence of death that was before him arose post-mortem?
Attorney Pattis?
Yes, sir.
I'm a little bit confused. Are you saying there's no evidence of death or no evidence of murder?
As a matter of logic and as strict evidence, there's really no evidence of murder even. But we didn't argue that below, and we don't need to go that far in this case. What the trial court had before it and the appellate court had before it was the record that is before you. And that is, there are body parts. I gather the loss of those parts are consistent with death. We're not going to claim that she's alive and wandering around without limbs somewhere. That's a morbid suggestion. But even assuming there was death, Justice Robertson, there is no reason to say that a post-mortem disarticulation can be leveraged into cause or manner of death. It simply makes no sense. And as we argued in our brief, mechanism of death here matters. It was entirely a matter of speculation for this jury to conclude that she was murdered and that she was murdered by Mr. Richards, who had the specific intent to do so. I think that Dr. Carver's testimony was perhaps better in accord with the evidence, and his report was in front of the jury, and that he could not reach a conclusion as to cause or manner of death. And that really is the only logical conclusion you can draw from post-mortem disarticulation of extremities. The distinction between cause and manner of death matters a great deal. It may be that you conclude that the loss of these limbs is consistent with homicide. And again, we're not prepared to argue that you have to conclude otherwise. But manner of death, there are four manners of death in the medical examiner's lexicon: homicide, suicide, accident, and unknown. Call it a homicide. But what was the cause of the death ultimately? It couldn't have been the removal of the limbs. Those were post-mortem. So somehow this young woman met her demise prior to the disarticulation, and the record is entirely silent as to that. And thus, I see a hand raised, and I'm somewhat new at this, so I'm sorry to stop abruptly. I'm just going to take the question now, if I may, and I'll get used to this, I hope.
I'm sorry, Mr. Pass, and that's quite all right. What we try to do is we're just getting in the queue when you see the hand up, and so when you get to a natural pause point, then you can pause, and I'll ask the justice the question. But since you've already paused, I'll go to
I didn't want to be rude and ignore it.
Well, thank you, counsel. Appreciate it.
That's nice of you. And I think this is going to be right in with keeping with what you're saying. Are you saying that the jury couldn't have convicted just on Dr. Carver's testimony? Let's say that Gill didn't testify, or do you need a medical examiner if the limbs are found and they're well, I guess somebody would have to decide if they're hers, but the jury couldn't still conclude you'd need either Carver or Gill or both, or you're saying it can't be Carver?
I don't mean to be cute and avoid the question. I think that post-mortem disarticulation matters a great deal. So I think you need that testimony for my argument to succeed, because the presence of limbs, and it's a morbid case, I don't mean to sound ridiculous. The presence of limbs are not a happy fact, obviously, for the defense. It's a circumstance that is certainly consistent with death. But when you have the unrebutted testimony that this was post-mortem disarticulation, that begs the question of cause and manner. So I would say on this record, there would never have been sufficient evidence to submit the question to the jury. Justice Robinson, I see you have a question.
Yes, I'm just wondering about the totality of the circumstances that we have here, where you have a defendant who has some kind of medical knowledge. You have a body that's been disarticulated post-mortem. It's one of those questions that always sort of vex me. What's the difference between speculation and permissible inferences? I'm never quite clear on that, and I don't know anybody in our profession who ever can truly be very clear on it. But help me with that.
Yeah, well, I mean, it's a great question. And I mean, I've seen the court engage in some spirited debate on that recently in State versus Rhodes. You know, what's the difference between a reasonable inference and an evidentiary gap filled with speculation and surmise? And I think this case illustrates it. So let's talk about the circumstantial evidence that supported the state's case. I've referred to it as 8 streams. On reading the state, I'll put a 9th in, one that I didn't emphasize enough in my brief. Mr. Richards knew the young woman, and he had a troubled relationship with her. Okay, that weighs in the state's favor. There was an isolated act of violence a month earlier at the stayover at his patient's home, and some troubling circumstances where he appeared in her presence. Okay, that creates suspicion. A month earlier, he said to someone, he was a nurse and could get rid of her. That hardly constitutes a statement of present intent 1 month earlier. But to address your question directly, this man was an LPN, not even an RN. And so he had some familiarity with the human body, but to go from there to the suggestion that this undergraduate familiarity with the structure and function of a body led him to be a skilled, in effect, mortician, I think is a leap. And at some point, the piling of inference upon inference crosses the line from a reasonable inference to speculation. I know that the two-construction rule no longer applies, but there used to be a rule that if evidence could be consistent, it could reasonably be interpreted in a manner consistent with innocence and consistent with guilt, the presumption of innocence required the non-inculpatory inference. But that really does beg the larger question: what's a reasonable inference? To go down the list of other items here, the state's domestic violence expert was permitted to testify, and perhaps that wasn't an abuse of discretion. But if you look at what happened in the Beth Carpenter case, when they sought to introduce an expert on dependent personality disorder, that was kept out as too remote, absent a foundation in this case. In this case, the domestic violence expert said in 30% of cases, a prior instance of violence leads to acceleration. So even on a mere preponderance test, that's not more likely than not. And you again begin to see the inference piled upon inference. Some of her DNA was in the car. Yeah, but she was a frequent guest in the car and in his home. They were known to one another. There was telephone metadata that put her phone in the general vicinity on the day that she disappeared from campus. And that phone stopped a month prior to her body parts being found. And then there's the geographic propinquity to Mr. Richards' home of where the body parts were found. I believe it was 1.8 miles away. Again, a highly congested, well, a highly urban area. And then there was the condition of the car, which had been cleaned, and the bathroom fixtures, which were being replaced in his second home. I believe there was evidence that he was in the midst of reconstructing that. So I think taken together, oh, and then, you know, the one I didn't address, which I'm sort of surprised the state did, he had some duct tape in his shoes to appear 2 inches taller. And so he had the little man syndrome, and he was going to be violent because he was 5'7", but wanted to appear to be 6'1". I mean, that illustrates the danger of circumstantial evidence. At what point does the court's gatekeeping function say, we're going to go this far and not any further? I'm attracting questions, and there are 3 of them now, so I've lost track of which one was first.
Thank you very much.
You're muted, Chief, but
Sorry about that. I had a problem finding the
Justice Eckert go? I've asked the question.
Justice Doria.
Oh, okay. I want to go back to something you said in when you were listing things. I think it was Mr. Wright's testimony about the comment that, you know, I'll get rid of her. You know, I'm a nurse, and the statement you made is that's not evidence of present intent. I want to just probe why that couldn't be, if the reason for that statement was because she was trying to break up with him. And a month later, that's what's happening. She's trying to break up with him. That's what the evidence is. And so why can't you use that statement to perhaps infer intent?
Well, clearly the trial court said you could, and I guess when I read through that, I was thinking about the temporal limitations on excited utterances. And so what makes an excited utterance is the lack of time to fabricate. It becomes reliable because it comes under circumstances that are so shocking. I suppose working against me with respect to your question, Justice Dioria, would be, well, okay, he had that intent and the intent remained throughout that month. This was as the relationship ended. But I think there has to be some discipline in trolling a person's utterances over the course of months and perhaps years to avoid sifting only that which is inculpatory and then importing it into present intent on events that occur much later. You know, the state criticized me for saying for using the Leniart template in discussing this on the grounds that Leniart was really a no-body case, and this is not. I would say this is the functional equivalent of a Leniart case, that in the absence of cause of death, where the only remains that are present are disarticulated remains, this is a case in which the body cannot speak as to its murder. And thus, in a no-body murder case, Mr. Wright's case under the corpus delicti rule would perhaps not have been admissible. I think permitting it here it submits him to the danger of what I'll call the trawling effect, trawling back through a person's past, finding the 1 or 2 remarks that they've made in the course of a long relationship and saying, see, this shows that he meant to kill her months after he said it.
Great, thank you.
Justice Eckert.
Morning, Mr. Pattis.
Morning, Justice.
So, you know, having been part of the dialogue in the Rhodes case, I'm certainly acutely aware of the difficulty and of drawing that line. We're not going to figure it out right now. You know, come up with a formula because there isn't one. And as judges, you know, we tend not to want to admit that it's ultimately subjective, but that's where I am anyway. But it's not unguided subjectivism. And so, you know, as you go through these many factors, you know, at some point they combine to to be strong enough to let the jury decide, right? And so the question is, how many of these factors do you need before it's a jury case? I tend to be maybe sort of a skeptic on this stuff, maybe more than others. It sounds to me like a pretty good circumstantial case. We can pretend otherwise, but I mean, she's dead. And it sounds to me like she was murdered. It's certainly a violent disposal. You don't see many or hear of many, or I can't think of many situations in which someone dies innocently and then is secretly disposed of like this. I suppose it could happen, but it just combines with a whole bunch of other things, including his jealousy and demonstrated use of violence, apparently at least on one occasion, toward her. And what about the fact that he was the last person to be seen with her when she was alive? So I guess I'd ask you to comment on that last factor. And also my question is there any case, all the cases in existence, is there a case that you'd point us to that actually holds the evidence is insufficient, that you think is similar?
As to that latter, I've not found one where disarticulated remains were presented as proof of murder, and this may be the first one. It's hard to imagine that in the course of a long republic. I did have occasion in connection with another case that ended abruptly not long ago to review the no-body murder jurisprudence, and what I learned is the obvious to you all, but wasn't as obvious to me since I'm not a justice, that there was a point where you could not prove murder without a body. That body was a necessary element, but that was held to benefit maritime bad actors. Because if you all go out to sea with the captain and you come back and the captain's gone, it'll never be murder because you took care of that. And so the court concluded that, or the courts have concluded that in the absence of a body, evidence that is corroborative of the criminal intent is necessary, but there needs to be limits on it to avoid speculation. And so my view here is that in the absence of a mechanism of death, we've got that problem. I was hoping Justice Kahn would be on this panel because I tried a case with her involving Abimael Ramos, which has been sustained on appeal. But this was a case where a woman was shot in the stomach and the defendant contended that there was a home invasion. The jury rejected that, and in closing argument, we had to say, well, you're aware of the cause and manner of death. The manner of death is homicide. The cause of death was the gunshot wound. But realistically, ladies and gentlemen, who shoots a person at close range in the stomach to kill? You shoot in the head. And I mean, it's not the sort of argument you go to law school dreaming of being able to make someday, but our job is to follow the evidence and ask the jury to draw reasonable inferences. In that case, Mr. Ramos was acquitted of murder, but convicted of assault or manslaughter with a firearm. Now, to get to your question of these factors and at what point does enough become enough, I think there is every reason to suspect in this case that Richards was involved in an untoward act with her. There's every reason to suspect that there was violence, perhaps on the very day she went missing. She did go missing on the 23rd, I believe, or the 23rd of April. Her body wasn't found for 4 weeks later. Where was she in that 4-week period? Now, her phone went silent that day, but in my brief, I posited several possibilities for which there is every bit as much proof as intentional murder. They quarreled. She fell out of the car. He struck her. She hit her head. She ran from him the day she disappeared. Somebody abducted her and killed her themselves. All of those events are equally possible, and there is no way to rule them out. And so from a defendant's perspective, if you're defending him, how do I ask for a lesser included offense, as I did in the Ramos case? That was the difference between a 60-year sentence and a 40-year sentence, which may not feel like much on the day sentence is imposed, but as a matter of law, it was the right sentence. In this case, Mr. Richards never had that opportunity because there was no evidence about causation of death. And we say that you can infer intent and by way of circumstantial evidence Isn't that by way of cause of death? It doesn't cause of death shed light on that. We don't have that. What we have is evidence that was not strict. We don't have what we need, which is evidence of cause of death. And what we do have is plenty of what's not necessary, motive, in the form of the domestic violence expert and the comment made to Mr. Wright. And I'd ask the court to take a look at Mr. Wright's testimony. I realize this is a sufficiency test, but Mr. Wright was one of the luckiest larcenists in state history. You know, he stole $75,000 from one employer and got AR. I want to know who his lawyer was. And then in the second time, when he stole another $1 million in exchange for the cooperation he gave to the state against my client, he got another walk. Who gets that? And is that the sort of evidence that we're going to say permits a reliable inference? Now, I understand, Justice Eckert, those are jury arguments. Make them to the jury rejected it, and your role is to determine whether this was whether this is whether this is not the right verdict, but whether it is a verdict that is consistent with the evidence. Well, it kind of is. Thank you, Justice McDonald. I know you've been waiting to have that sign to show me for a number of years. And I appreciate you're not pressing the mute button. This was just too easy for the state. The hard work of speculation was substituted for the hard work of proof. And, ask yourself, what do the elevator boots or the elevator tape have to do with this? What does the DNA in the car have to do with it? What does the domestic violence expert have to do with it? What does Wright's testimony? Yeah, all these little factors taken together create a picture that is consistent with guilt, but is it really probative evidence? And when the medical examiner himself says, as he said directly, there is no way to tell how it happened, where it happened, when it happened. And the only evidence you have as to mechanism of death is disarticulation wounds that are post-mortem. I don't think there's any evidence before the jury about cause of death. All you have is manner. And we could have contested manner. At trial, it could have been contested. It wasn't. I do think it's reasonable to infer that these wounds are consistent with death, and that would be a bridge too far. So we've chosen not to walk it. But the bridge we're on leads to only one destination, and that is that this was a verdict that was a product of speculation rather than proof. Justice Robinson, there was a hand up for you a while ago, and then your colleagues ran away with the show.
No, you answered my question, sir. Thanks.
So, if you look at some of the cases that the state recites, for example, the Otto case, they contend, and this is on page 13 of the state's brief, that this is helpful. But, in this was an instance where bone fragments and charred remains of the defendant were found in a fire pit. Now, we don't know enough about what those charred remains were. I suppose counsel could have argued that was just part of her body, but I think that creates an image that's simply lacking here. So I know I have 3 minutes left. I'm not going to use every minute. I've said what I have to say. By way of summary, I'll simply say that I'll end where I began. In my view, the medical examiner's testimony alone is sufficient to reverse this. I understand it's a horrible, horrible thing to lose a child in these circumstances, and that there was every reason to suspect Mr. Richards. But to try him 3 times on this evidence and in the end convict him on the basis of suspicion is a bridge that I'd ask you not to walk.
Thank you very much, counsel. You have your remaining time. Attorney Baer.
Thank you, Your Honor. May it please the court, my name is Catherine Baer. I'm a senior assistant state's attorney here on behalf of the state of Connecticut in this appeal. Attorney Pattis has said a lot of interesting things, but what he hasn't said today is how the appellate court got it wrong. And that's the question before this court, which is to determine whether the appellate court correctly applied, of course, the well-worn 2-pronged standard of evaluating a sufficiency claim, which is, number one, construing the evidence in the light most favorable to the verdict, and then taking those facts and drawing all the reasonable inferences in favor of a guilty verdict and determining whether that establishes guilt beyond a reasonable doubt. And it does. And I'm going to start with Mr. Pattis's point about the medical examiner's testimony. In the state's view, that does absolutely support the second element that the state bore the burden of proof, and here's why. When Dr. Gill rendered that expert opinion to a reasonable degree of medical certainty, he did so based on the condition of the remains, and he specifically answered a question from the state that this does not happen in nature. In other words, this sharp object injury that occurred post-mortem was the result of another person's act, effectively, and it bears a lot of resemblance to precisely the situation in Otto with the charred remains, as evidence of the extreme and gruesome efforts that one might go to in order to conceal his involvement with the death and disappearance of the victim in this case.
Counsel, I think Attorney Pattis would actually agree with you that it does show some violence after a death, but the question is, what caused the death? Other plausible explanations other than a homicide.
So that point is well taken, and the fact is, under our law, that proof of the exact cause of death is not required. What we have, though, is this compelling amalgamation of other factors that supports the reasonable inference that, however the death was caused, it was at the hands of the defendant. In other words, this evidence placing the victim with the defendant she's the last person seen with her, the cell phone evidence, and of course the strong evidence of motive in this case.
Well, as I understand Mr. Pattis' argument, even if you had proof of a homicide, you don't necessarily have proof, except for using inferences of a murder versus manslaughter versus someone falling out of a car and somebody panicking and disposing of a body. All those explanations are plausible.
Well, as Your Honor indicated, it is a reasonable inference of murder, and that was the jury's task. And here, our law recognizes no difference between direct and circumstantial evidence. So as long as that inference was reasonable, which it was based on our law also recognizing that the jury is permitted to create effectively a chain of inferences based on the evidence, then that is the lens through which this court must view the evidence in favor of the jury verdict.
Thank you, counsel. Justice Daria.
I'm sorry if this is a stupid question. You'll tell me nicely, I'm sure, if it is. But how is he even an expert on whether it was a homicide? If he has, I mean, he can testify that this doesn't happen in nature, meaning taking dismembering the limbs with some sort of an object. But, if somebody died of natural causes, as the chief is saying, that, there could be any number of explanations. So what's his opinion based on? Is it it sounds like he is making the inferences that the jury would be asked to based upon a lot of factors, but I'm not seeing how that's a medical question, other than that he needs to come up with, one of the four causes, as Mr. Pattis would say.
Well, Your Honor, just hit the nail on the head, I think, with where you ended, which is that he is tasked with examining these types of remains and making assessments about death, and is qualified medically and through experience to do that. But here's the key point. The jury had Dr. Gill's testimony in front of it, which they were free to reject, and that was an argument that could be made to them and was made by the defense in closing argument. And as Attorney Pattis pointed out, they had information relative to Dr. Carver's assessment of the situation as well. In spite of that, the jury chose to credit Dr. Gill's testimony in this case, and that testimony permitted a finding on that second element.
Let me just ask you a follow-up on that. Don't you think, or tell me if you concede, that you wouldn't have a case, not just a weaker case, if Dr. Gill didn't testify, but Dr. Carver did, and he says whatever he says, but he doesn't know what the cause of death was or the manner. Are you telling me you couldn't get a jury? Would you concede that you can't get a jury to convict on that evidence?
No, Your Honor.
So you could?
Yes, Your Honor.
I guess I'm just not understanding what Dr. Gill's testimony was. What he would base homicide on, other than what an investigator would.
Well, Your Honor, on that point, actually, that was the testimony in State versus Otto, right? The state presented a forensic expert regarding the condition of the charred remains, and in that case, that expert actually was permitted to testify that the deliberate cremation, was suggested a homicide. So here we have even more than that. You have the medical examiner who has re-examined the remains themselves, the photos, Dr. Carver's report, and has come to his own conclusion, supported by his medical training and experience, to render this opinion that the jury was entitled to rely on.
Okay, thank you.
Thank you, Justice Story. Justice McDonald? Justice Ecker.
I'll accept that momentary seniority, and Justice McDonald, I'll try to be quick. I guess my question is a little more theoretical and maybe two parts. First, do you agree with Mr. Pettis that there are various plausible explanations of how the victim died? It could have been an intentional homicide. She could have been knocked down the stairs during an argument and died. Clearly, there was concealment after the fact. But do you agree with him that the cause of death could be there's a number of sort of reasonable inferences one could arrive at, or no?
There are multiple inferences from the evidence. I agree to a certain extent, and those were presented to the jury and for the jury to accept or reject. And
that's my question. So, and I understand one answer to this is because that's what the law is. So that's the easy answer. But I would like a more thoughtful one if you have it, which is this. I understand we're supposed to say, well, if it's reasonable inference, then it's sufficient evidence. I'm wondering why, though. I mean, let's imagine hypothetically that it's really true that we can't choose between, let's say, manslaughter and murder. We just don't know whether he intended to kill her, and the jury didn't know. Why is it that that's beyond a reasonable doubt all of a sudden? I mean, haven't we just watered down the reasonable doubt standard by our standard of review?
No, and here's why. Because it's intent can never be known, right? That's the jury instruction. You can't open up somebody's head and figure out what they're trying to do. So we have to look at all these other pieces of evidence, and they come together in this cumulative effect that in this case, from the state's point of view, this case is nowhere close to speculation. And I understand Your Honor's confusion and what the Chief Justice was talking about in terms of this line between impermissible speculation and inference. It seems very blurry from the state's point of view as well, but we're not even close to that line in this
Let's
case.
say you're right about, I know I am interrupting, I'm sorry, I'm trying to get through it, and I promise Justice McDonald I was going to be quick, famous last words. No, I understand. So let's say it's more plausible. He was a killer. There's all this other stuff. I mean, he was responsible for her death. I shouldn't say there's all this other stuff. But why is it more plausible that it was a murder than some other type of homicide? I mean, that's what I don't get. And saying, well, that's reasonable and it's up to the jury doesn't help us really decide whether it was proof beyond a reasonable doubt on that issue. Does it?
I think it does. This court, as a reviewing court, has to defer to the jury's assessment of those inferences and their ultimate conclusion, taking into account what the defendant was charged with, what they were instructed on, and how that evidence all came together as indicated by their verdict. And then that verdict is what is entitled to deference. The evidence is viewed in support of that verdict on review. It's not an easy issue, but I see Your Honor's concern on that.
Thank you.
Senior Associate Justice McDonald.
Thanks, Chief. Well, Justice Ecker effectively asked my question, probably better than I could have phrased it. So let me take it in a slightly different direction. You're right. We can. There can be a chain of inferences. The problem with the chain of inferences is that every additional link actually weakens the chain. And so, you know, I just don't. It apparently is clear from the state's perspective that this isn't even close to speculation, but it seems to me that it's actually well within the potential of speculation. So I'm going to press you on what the chief talked about earlier and just Secker. Where, from your perspective, what more would have been necessary to move this from reasonable inferences into speculation?
I think we would have had to present all these pieces that came together, right? The motive, the time and opportunity, the condition and location of the remains, the cell phone records, the consciousness of guilt evidence, the demolished bathroom in the Ansonia property. I don't know the specific number that I would have to take away from Your Honor, but it'd be a lot. It would be more than half of that evidence probably in order to get into the realm of impermissible speculation here.
Let me ask it maybe in a different way. What are the reasonable inferences in the state's view that distinguishes this homicide from from manslaughter to murder? What's the distinguishing feature here that, to Justice Ecker's point, I mean, maybe there was a violent, maybe he was prone to violence, maybe he did have an altercation, maybe he punched her and she fell down a flight of stairs. So what's the reasonable inference that takes it from a manslaughter to a murder?
It's really the domestic violence evidence in this case, which, as the state argued in closing, that this case was about power and control. And we know that this was a victim who was trying to get out of this relationship. We know that when she attempted to do so, just shy of a month prior to her disappearance and death, the defendant reacted with physical violence, choking her to the point where she couldn't breathe. We know that 2 or 3 days before her disappearance, she tells her sister she intends to break up with him again. And we have his statement, the defendant's own assertion, which the jury was entitled to use as both evidence of intent and as well as evidence of the intent to kill, and in fact that he did so, that he lived up to that objective, because of course because he's the one who said that, and he's the one who's linking, right, this idea of his profession with some type of know-how as to how to accomplish this fact, which is that malice aforethought leading to this ultimately fatal event. So, you know, it's a little bit different from the cases of Sivry and Otto, where there wasn't this long-standing relationship. It's more like the Richard Crafts case. And actually, to go back to Your Honor's just prior question, you know, in that case, the defendant had made a challenge to this inference on inference chain, right, and argued that the state had to prove each link in the chain beyond a reasonable doubt. And this court rejected it. It said, no, you know, that each link can go from one inference and ultimately lead to a conclusion. So I don't know if that answered Your Honor's question completely.
It really doesn't. I mean, everything you've recited could equally support manslaughter or murder, and it really hasn't clarified it for me. If you want to take one more shot, otherwise I'll let it go and I'll figure it out later.
Well, again, let's take his statement, right, that I'll get rid of her. Just like in the Richard Crafts case, after the fact, Mr. Crafts told his brother-in-law when they're deep diving looking for the body of Mrs. Crafts, let him die, the body's gone, there's no body. It's that a get rid of her was, the jury reasonably could infer, was a statement that he intended to kill her. In fact, in another case cited in the state's brief, that Edwards versus Commonwealth of Virginia case, it's an intermediate level Virginia case, but the facts are alarmingly similar. There was a statement made from the defendant to the victim in another sort of more long-standing domestic violence type relationship setting. I'll get rid of her. There was a choking incident two months prior to the victim's disappearance in that case. The defendant missing work the next day, and that was actually a corpus delicti case. So here we have the remains showing up in the state that they are in proximity to the defendant's home, all comes together to create this cumulative effect of an intent to kill, and in fact causing the victim's death.
Thank you. Justice Daria?
Thanks, Chief. Could you illuminate if there is any illumination in the record about how the state came upon Mr. Wright's testimony? That is, how did it find out about it? Was he already facing charges when it found out that he had this statement? You know, he could provide this statement, or was this something that the state knew, if the record reflects it, before he had charges and then this was arranged, if you know?
Sure. Mr. Wright spoke with the police on May 8th, 2013. There was some cross-examination, if not also on direct questioning regarding how and when he spoke with the police, and he gave this statement at that time. So it was prior to the discovery of the remains, but after the disappearance.
But what about vis-a-vis his own charges? Did you just say that?
I did not, Your Honor. Thank you. I'm not sure. Again, I would refer the court to the cross-examination, and I stand by whatever's in there. He did have pending charges. His first set of crimes was from 2010. But I'm not entirely clear.
That's fine. Mr. Pattis did the cross. Maybe he'll know. He'll let me know.
It was actually different counsel below, but
okay.
But he might know it. In short, it's really the main issue here is the application of the standard review and whether the appellate court got it right. And Judge Bishop did a really nice job in the appellate court decision, laying out the evidence that supported both of the elements of murder here. With respect to, I think Attorney Pattis was talking about whether there was any case law regarding this disarticulation or dismemberment. The state as well did not come across that specific factual pattern. I know the Georgia case, that Parker case cited in the state's brief rather, dealt with partial remains, but the state as well did not come across this particular set of facts, which really, as I indicated before, ranks up there with the situation in State versus Otto of this deliberate cremation and concealment, which of course as consciousness of guilt evidence can go toward informing the intent element of the murder charge. I'm happy to answer any additional questions that the state might have, but if the court has none, I would ask this court to affirm the appellate court decision, which correctly applied our jurisprudence in this circumstantial murder context and affirm the judgment of conviction. Thank you.
Thank you, counsel. Seeing none. Attorney Pattis.
I've made notes. I'll try to recall who asked the questions, although reading my handwriting is the challenge. Justice Dioria, I don't think the medical examiner's opinion about homicide should have been admissible at all. I don't think it was based on anything. I cannot imagine a logical set of inferences or hypothesis that made it admissible. He had the only evidence he had that he could opine on as a medical expert was the physical corpus that he had before him, and those were post-mortem disarticulation wounds. It shed no light whatsoever onto the manner of death. It did create an inference that the body was disposed of in a nefarious way, but how the disposer acquired the body was an open question, and it was for the jury to prove. So I think his opinion was entirely speculative. And sir, he did, there's a distinction that I'd ask you to consider that you didn't draw when you asked the question, and that is between manner and cause of death. Even if the medical examiner was not erroneously permitted to offer that testimony as to manner. He had nothing to say about cause of death. And in the absence of, so cause, fall, gunshot, strangulation, knife wound, the record is entirely silent on that. So we believe the medical examiner's testimony was entirely speculative. That on Gill's testimony, on Dr. Carver's testimony, I think there probably would have been judgment as a matter of law, simply on the grounds that there was no evidence as to manner of death, no evidence as to cause of death, and there was an insufficient amount of evidence to suggest that she was in fact dead. Now, the state didn't treat this as a typical corpus delicti case, as in Leniart, and prove the sort of relationship she had in the community so that the jury could draw the predicate question about whether it was reasonable to conclude that she was dead. That was a fact that was assumed without proof. Thank you, Justice McDonald. Justice Eckert, I think the manner in which this case proceeded did water down the standard of review. It eliminated the standard of review. What makes these, the line of homicide cases in Connecticut goes something like this: murder, specific intent. Then there's reckless manslaughter, which is observing a substantial degree of risk of serious risk of bodily harm and proceeding in spite of that risk. And then there's criminally negligent homicide. There is just nothing based on the evidence in this record, zero, that permits anybody to draw an inference one way or another. If it was a homicide case, there's a difference between causation and correlation. And ironically, today we have this argument on the day that the George Floyd case opens. It's accepted widely throughout the world that Floyd's death was a result of race-based animus. Because the officer who was present at the time of his death was white and he was black. If you've seen the videotapes, you know the difference between proof and assertion, and you know the overwhelming danger of prejudice. And our conclusion is that this was entirely prejudicial. Justice McDonald, I see your hand is up, or your icon is anyhow.
Yeah, counsel, on that point, your opposing counsel says the distinguishing, among other things, says the distinguishing information here that distinguishes this from manslaughter to murder is the statement, "Get rid of her." What's your response?
I will never say anything about my wife again, for fear that if she comes into an accident, I will be accused of murder. I mean, I'm going to get rid of her. Could that mean break up with her? She's seeing another guy. I'll get rid of her. I'll get another woman. Normally, when they're
But I mean, taking that statement, is it an unfair or an improper inference that getting rid of her meant murder?
It's a possible inference. Yes, it's a possible inference. But does that alone remove the case from speculation? And at what balancing test does a court conclude? And if that's all you have, is that enough? And does that suggest that he specifically intended to kill her? Or that they had a struggle, or that he was frustrated in his intent and he hit her and she didn't die. She died later. I just don't know, and I can't know on this record. How do you defend that? How does trial counsel ask for an LIO when the lesser included offense, when it has to be based on some evidence? When the state's case has a hole in it and there's no evidence as to causation of death, the defense is by definition prejudiced because you can never even pursue an LIO.
Thank you.
Justice Robinson?
Attorney Pattis, I know this is not a corpus delicti case, but are you basically arguing we would have to take another look at our jurisprudence as far as those types of cases and this type of case?
I didn't brief that, so that would be unfair of me to say, yes, you should do the work that I didn't do. I say that because I was stung by the state's criticism that Leniart was somehow distinguishable. And in preparation for the argument, it struck me that this bears similarity to a corpus delicti case. And thus, because what we have is no evidence as to cause of death, really no evidence as to manner of death, in fact. And therefore, we're arguing about the absence of a person and what caused their absence. And like Leniart, what made Lanier a close and difficult decision for this court, yes, sir, I see it, Justice McDonald. What made that a close and difficult decision for this court was the jailhouse informant confessions, and the court concluded there were enough of them, including eyewitness evidence that Mr. Lanier was with her the night she died, including eyewitness evidence that he confessed to her murder the day after to an informant, that this court held the corroboration requirement was met. There's nothing like that in this case. Wright's case, standing alone in a corpus delicti case, would be admissible error because it's such thin rule. I'll get rid of her. Nothing to corroborate that, in fact, he did. As to the Wright question, I believe it was you, Justice D'Oria, who asked this. On page 7 of our brief, we wrote, and I think this is accurately reflected in the record, that Wright testified and told the jury that a condition, after sentencing, but told the jury a condition of his, and this was on the second arrest, that a condition of his probation was that he testify truthfully. So he had been made aware of the fact that there were liberty interest consequences to his testimony.
Yeah, and I get that his motivation to testify. I wondered if there was anything in the record in the examination that reflected that he made that statement, that police knew of the statement before he was arrested, before he pleaded, before he was on probation, or
I didn't see it in the record, sir. I didn't see that. I would have included it. So for all of these reasons, it's an unpopular case. I know the state admonished me for asking you to reconsider this multiple trial problem, but I'll end on this note. It's the state that has the burden of proof here. And, in our view, the state failed to meet its burden after a full and complete trial twice, and it came back a third time and with a condensed version of the case and failed to meet its burden of proof again. And the result is Mr. Richards has been convicted based on inferences that are possible. But it's much like reaching the conclusion in George Floyd's case. He's missing, he's dead. A white officer is with him. He was killed on account of race. In this case, Mr. Richards had a dispute with her. She's gone. He must have killed her. There's just something wrong with that reasoning. It's insufficient as a matter of law, and we would ask you to reverse.
Thank you very much. With that, we will adjourn for the day and open again tomorrow morning at 9:30. Thank you, counsel. Appreciate you coming in for the argument. Please stay safe and stay healthy. Take care.
Thank you, sir.
Thank you.